Masechet Baba Batra, Daf, Kof, Yod, Gimel. We begin by analyzing two Pesukim that are almost identical, and why do we need a repetition of them? They're both in the last chapter of Sefer Bemidbar, chapter 36, Pesukim 7 and 9. The context is Benot Selofchad, and the last law after the people of Selofchad's tribe complained that they might lose part of their inheritance if Benot Selofchad go and marry another tribe. So I say, okay, here's the law. Libnos Selofchad lemor, lato benhem tiyena nashim. They can marry anybody that they want. Ach lemishpachat matavihem tiyena lenashim, as long as the husbands that they marry will be within their father's tribe. Why? And here's the first pasuk: Velo tisob nachala libnei Israel mimateh el mateh, so that no inheritance in Bnei Israel will pass. Tisob means to pass over from one tribe to another. Kish benachal mateh avotav yidbeku Bnei Israel, so that each person in the inheritance of his father's tribe will stick. Right? Yidbeku Bnei Israel, that all the land should stay in the same tribe as it was. Okay, that's pasuk number 1. And now the next one says the first these 2, 6, 7 was regarding the Benot Selofchad in particular, and now it expands it to say V'chol bat yoreshet nachal bnei Israel lechad mishpachat mateh aviha tiyeh leisha. Anytime in the future that a daughter will inherit land from one of the tribes, she also has to marry the tribe of her father. L'man yirshu bnei Israel ish nachalat avotav, so that Yisrael will inherit the land of their forefathers. V'lo tisob nachala mimateh lemateh. Very similar. So that land will not pass from one tribe to another. Like here, Libnei Israel, this doesn't have Libnei Israel, just says mimateh lemateh acher. So that's one difference. Ki ish benachalato yidbeku matot bnei Israel. Each person within his inheritance should stick, remain within their tribe. So it has similar words, just slightly different. Okay, so why do we need both of these pesukim? Is going to be our subject now. Tanya, besibat haben v'tanya besibat habal. There are two baraitot. One focuses on transfer from one tribe to another because of a son, meaning that when a woman, like in this case, will die, eventually it will go to her son. And her son, if she marries someone from a different tribe, then the son will also be from a different tribe, and then the land will go from one place to the other. And the second baraita talks about transference because of a husband. If she dies and she was married to a man from a different tribe, then when she dies, the husband from a different tribe will inherit her. So let's see. Tanya besibat haben. Here's the baraita that talks about transference by means of inheritance of a son. Velo tisob nachala libnei Israel mimateh el mateh besibat haben hakatuv medaber. So now quoting the earlier pasuk that says she should marry someone within the tribe so that land will not go from one tribe to another within Bnei Israel. That's talking about transference by means of a son inheriting. And now the Midrash doubles back on itself and said, wait, how do you know that pasuk is talking about transference to a son? Maybe it's talking about transference by means of the husband, that when she dies, the husband inherits it. Oh, that's why we have the second pasuk, pasuk 9, when it says that pasuk, that land should not transfer from one tribe to another. That pasuk is talking about transference by means of a husband. El mateh besibat haben hakatuv medaber. So why do I need the earlier pasuk that no inheritance should go from one tribe to another? Oh, that must be talking about transference by means of a son. So in the end, both of them are included. The earlier pasuk is about transference by means of a son. The later pasuk by means of a husband. But we need both, so that now I know that both are included. Tanya idach. Here is second baraita. Second baraita is the same as the first. It just flips around the order. So now this midrash, this baraita quotes the second pasuk that land should not transfer from one tribe to another, and says, "Oh, this is talking about transference by means of a husband inheriting. How do you know it's talking about the husband? Maybe it's talking about a son inheriting and transference by means of the son. כשהוא אומר, ולא תיסוב נחלה לבני עשיו ממטה אל מטה, הרי סיבת הבן אמור. המה אני מקיים, ולא תיסוב נחלה ממטה למטה אחר, בסיבת הבעל הכתוב מדבר. Well, that's why it says the earlier pasuk, that land should not transfer from one tribe to another. That one's talking about transference by means of a son inheriting. So what do I need the later pasuk for? It must be that is talking about by means of a husband. So in fact, both Baraitot agree that the earlier pasuk is talking about the son, and the later pasuk is talking about a husband. And so both of them are we care about, which means it's assuming that both a son, of course, and a husband can inherit when a wife dies, and so she has to marry into the tribe so that the land that she inherited will not transfer outside by either way, either means. So now everybody agrees that the pasuk that says mimate lemate, which is the later pasuk, everybody agrees that's talking about the husband. My mashma, how do they know? Why are they assuming that the first pasuk is the son and the second pasuk is the husband? What is there in the second pasuk that indicates that it's talking about a husband? Amar Rabba bar Rav Shela Amar Kera Ish. So the second pasuk says ish. Let's look here. Ki ish benachalato yidbeku. So it says the word ish, and ish means a husband, right? Ishi. Isha is a wife. Ish is a husband. But the problem is that the earlier pasuk also says ish. So that's what we ask. Hold on. Amar kera ish. Tarvahu ish keti behu. Both of them have the word ish. Okay, let's try again. Ela amar Rav Nachman bar Yitzchak amar kera yidbeku. Tarvahu yidbeku keti behu. Oh, the later pasuk says the word yidbeku, that's right here. Yidbeku means davak, vedavak beishto. Someone will cling to his wife. So this is the word yidbeku, although here it's talking about clinging to the land. The land should cling to the same tribe that it was in before. But yidbeku is an indication, it's a hint that we're talking about a husband and wife. But the problem with that is the early pasuk also says yidbeku. So the final answer is going to be, it says yidbeku matot. These two together, that one should be attached to the tribe. So these two together indicate a husband. Ela amar Rava amar kera yidbeku matot. So only the later pasuk says yidbeku and matot together. So the tribe, meaning cleave with it through marriage to the tribe. That means that she, a woman like Selofchad who inherit, should marry, cling to someone within the same tribe. So that indicates transference through the husband. Rav Asher Amar Kera mimate lemate acher uben lav acher hu. Rav Asher learns it a different way because the later pasuk says v'lo tisob nachala mate lemate acher, that inheritance should not go from one tribe to a different tribe, like a foreign tribe. Well, you wouldn't call a son a foreign tribe from the mother, because the son comes from the mother, comes from the father and mother. So you can't call that a foreign tribe. You can't call a son a foreigner because it's related to the mother. Rather, who can you call a foreigner? Well, a husband, because before they were married, they're from a foreign tribe. And so she's marrying someone from a foreign tribe. So it makes sense to say mimate lemate acher is referring to a husband, as opposed to the earlier pasuk that just says mimate el mate. It doesn't say acher, so it makes more sense to say from tribe to tribe if it's talking about a son, because the son comes from both tribes. But if you can say from one tribe to another tribe, a different tribe, well then that makes more sense that it's referring to a husband and wife. Amar Rabbi Abu, Amar Rabbi Yochanan, Amar Rabbi Anai, Amar Rabbi. Umatuba Mishemed Rabbi Yoshua ben Korcha. We have a long lineage for the following statement. Rabbi Abu said the name of Rabbi Yochanan, who said the name of Rabbi Anai, who said the name of Rabbi, and some determined that it was actually Rabbi Yoshua ben Korcha who said it. Minayin labal sheno notel bera'ui kebemachzak. How do we know that when a husband inherits from his wife, he does not inherit potential like actual? In other words, when a wife dies, then the husband inherits what she currently has in her hands, not something that is due to come to her in the future. For example, if a woman has someone who will bequeath to her when that person eventually dies, she has a parent or someone, let's say a parent, and when the parent dies, there's no brothers, and she is due to inherit something. If she predeceases deceases her parents, then the husband does not inherit that. The husband only gets what she currently has at the moment of her death, not things in the future. If there's any inheritance that will come to her in the future after she dies, that doesn't go to the husband, but rather it will go to her children. And if she doesn't have children, it will go to other members of her family, not to the husband. That's the law. How do we know? שנאמר, וסקוב הוליד את יאיר, והיא לו 23 ערים בארץ גלעד. מניין ליאיר שלא היה לו לסקוב? Same pasuk and question that we had before, although you see that we quote this again and we apply it to the current situation, so it's a slightly different derivation. So Segub had a child named Yair, and Yair had 23 cities in the land of Gilad. How did Yair, the son, have all these cities that he didn't get from Segub? Because it sounds like, right, Segub, while he was alive, had Yair, and while he was alive, Yair had all these cities. He didn't inherit them from Segub, so how else could he have gotten them? Of course, we said before, he could have bought them some other way, but now we're applying it to one particular case. Rather, here's one way. It could be that Segub married a woman, and that woman died during the lifetime of her bequeathers, let's say her parents. So her parents owned these 23 cities. But then Segub's wife died before her parents. So therefore Segub, the husband, did not get them. After that, those Segub's in-laws died, and then the inheritance goes not to Segub, but rather to Yair. And so, how did Yair get these cities during the lifetime of his father? It must be that Yair's grandparents, Segub's in-laws, or whoever, some other family member from which Segub's wife would have inherited, Segub's wife died before them, and that's why it didn't go to Segub. That would be only potential, which Segub doesn't get. Segub only gets actual stuff that she had at the time of death. Anything else goes to the grandson. So this teaches, rather must be that Segub married during the time, had a wife, and she died she died in the lifetime of her bequeathers, and then the bequeathers died, and Yair inherited from them. So that's a proof for this law. And we have another proof. Ve'omer, ve'elazar ben Aaron met ve'yikberu ve'gomer minan Pinchas shelo haya lo le'elazar. Pasuk that we quoted before. Elazar, the son of Aharon, died, and they buried him in the hill of Pinchas, his son. Now, how did Pinchas own this hilltop where they made a cemetery during the lifetime of his father Elazar? So obviously he did not inherit it from his father. So how did he get it? מלמד שנשא אלעזר אישה ומתה בחיי מורישיה ומתו מורישיה וירשה פנחס. So this teaches that Elazar was married to a woman, and she died during the lifetime of her bequeathers, let's say her father. And her father owned this hilltop, but she died first, so therefore her husband, Elazar, only gets anything that she currently owned, but she didn't yet own that hilltop. Afterwards, those bequeathers died, let's say her father, and then, since it was only potential, so Elazar does not get it, rather the grandson will get it, and that's Pinchas. That's how Pinchas got this land during the lifetime of his own father. And so that's a second proof for the law that we just mentioned. Umay ve'omed. Now, why do we need two Pesukim to teach the same thing? Because you can explain Yair in a different way, a simpler way. Yair was married to a woman, not Segub the father, but Yair the son was married to a woman, and that woman died, and Yair's wife, had property, and when she died, he inherited from her. So it could be that he acquired the land in that way. And so that's why from that one pasuk we would not be able to learn that the law regarding a husband only inheriting the actual, not potential. So that's why I need the other pasuk, Talmud Lomar Elazar ben Aaron met. So a second pasuk, it can't be talking about the same thing, must be talking about something different. This whole methodology is actually quite interesting, because these are not like legal verses in the Torah where you'd say, why does it have two verses to teach the same thing? These are stories. This is a genealogy. But you see, the approach of the Gemara is that even stories, and especially genealogies in Divrei Yamim, are not taken to be just stories, like, okay, why do I need to know this? But rather, these are genealogies that are hinting to indications of other subject matters, sometimes symbolisms regarding the character of a person, and in this case, an actual indication of a law. And so if there's two different Pesukim about the same phenomenon, then it must be that one of them is coming to teach us something else, otherwise it would be extra. And if you say that Elazar, the son of Aharon, that Pinchas, the son of Elazar, how do you know that he got it through this inheritance way? Maybe he got it because someone dedicated a field. He consecrated it to Kohanim, and he got it in that way. How do you know he got it from an inheritance at all? And the answer is because it says Beno, that Elazar was buried in the hilltop of Pinchas Beno, his son. Why say his son? We know that Pinchas is the son of Elazar. It adds the word Beno to say this was an inheritance, a piece of land that was fitting for Elazar, that he could have inherited potentially if his father-in-law had died first, and then it would go to the daughter, and then the daughter died, then Elazar would have inherited that hilltop. But just because they died in the opposite order, so then he didn't get it. But it has to be something that potentially he himself could have gotten. So that's why it says Beno, that it was potentially his own. It was fitting for him. But in the end, because of the difference in the order that they died, his son ended up inheriting it. And so that's how you know from that word, extra word Beno, is a hint that it was this scenario and not just gotten by consecration. And so these two Pesukim together, we need both of them in order to teach a derivation of this law that a husband only inherits that which his wife currently has, and not something that will fall to her in the future. We now move to the next phrase of the Mishnah, Ubnei Achot. Tana b'nei achot velo benot achot. So the Mishnah teaches that sons of a sister inherit but do not bequeath. Let's go over this law. So if someone dies, it would go to his children. If he doesn't have children, it goes to the father. If it doesn't go to the father, it would go to the brothers, paternal brothers. If the person doesn't have paternal brothers, it will go to his paternal sister. Now this is kind of obvious because the idea is that it goes to a person's children, then it goes to a father. If the person doesn't have a father, it goes to whoever would inherit the father, had the father been alive and then died, whoever would inherit a father. So it's just like sons inherit the father and then daughters, so too if a person dies without children, so then it would go to the father. If there's no father, it goes to paternal brothers and then to a paternal sister. Now, if the sister also has died, but sister has children, so since that sister would have inherited had she been alive, so it just follows through that it goes to her sons. So this is just a logical progression that would go to the nephews. Now it would never work the other way around, because those sons, let's say they died and they didn't have any children themselves. Now who would inherit? Well, it would go to their father. Let's say they didn't have a father. And then it would go to their paternal brothers or their uncles or someone in their paternal family. The point is it would never go to their mother or anybody in their mother's family, because, as we said, this is the main principle, that inheritance goes through a father's family. So these nephews are part of the father's family in terms of the uncle, because it's the uncle's paternal sister. But the other way around, if from their perspective, if they died, then it would not go to the mother or anyone in the mother's family. So they are related by a father from the uncle. It's the uncle's paternal family. They are part of, because their mother is a paternal sister. But the other way around, when they die, then it can go to their maternal uncle, who that's who that same person would be. Okay, that's the law of the Mishnah. Now, a Baraita teaches that it goes to sons of sisters, but not to daughters of sisters. So let's say this person died. He had no sons, no father, no brothers, and it goes to his sister. Let's say the sister died also. So the sister has sons. It goes to sons. Let's say there's no sons. Well, then it said this Baraita says it does not go to the daughters of the sister. Now we ask, what does that mean? What does that apply to? This is only regarding precedence. It doesn't mean that they would not inherit at all. This Baraita is simply teaching that, let's say that sister has sons and daughters. Sister dies, and then now her brother dies afterwards. So the brother that died who has no other family, that brother has no children, no father, no other brothers, it goes to his sister. If the sister is dead, then it goes to the sister's children. The sister's children, it goes first to sons only. If she has no sons, then the daughters do get. So could be that a person will die, and then if there's no other family, then it will go to his paternal sister's daughters. That just goes in the order of progression. So this Baraita doesn't mean that those daughters cannot possibly inherit. It just means that the sons will inherit before the daughters. Tane Rav Shemuel bar Rav Yitzchak Kamed Rav Huna V'yarash Mekish Yerusha Sheniya Lirusha Rishona Ma Yerusha Rishona Ben Kodem Lebat Af Yerusha Sheniya Ben Kodem Lebat. So this teaching is not obvious, because although yes, we know that when a person dies the sons get and then the daughters get, we already discussed that. That's if a person dies, that's called Yerusha Rishona. That's the first primary inheritance. But we don't know that that would necessarily be true for a secondary inheritance. Like in this case, where a person dies, he has no children. So now it's only going to the sister, and then from there it's going to the sister's children. It's not going to those kids because the sister died and it was the sister's property, but rather the sister had died early, before. And now it's just going to them as a secondary inheritance because they are the closest relatives. So you might have thought that for secondary inheritance, maybe sons and daughters inherit equally. And that's why we have this derasha when it says ve'yarash. This pasuk, which is talking in general about if there's no other family member, then you give it to the next of kin, and so that giving it to next of kin is a secondary inheritance. And so this pasuk is bringing together, comparing the secondary inheritance to the first inheritance by calling it also Yerusha. And so just like Yerusha, the primary one that goes to a son, which I talked about earlier in that paragraph, and there a son comes before a daughter, so too a secondary inheritance, which it talks about in this pasuk, but it's right next to the earlier pasuk, so they're all juxtaposed to each other to teach me that it's the same law, that even for secondary inheritance, a son comes first, but then if there's no son, then the daughter will inherit. Tane Rabba bar Chinena Kamed Rav Nachman. Vaya biyom hanchilo et banav. Bayom ata mapil nechalot, ve'en ata mapil nechalot balayla. A braita that Rabba bar Chanina taught in front of Rav Nachman. He knew this braita, and so he was reciting it in front of Rav Nachman. And the braita quotes a pasuk from Devarim that's talking about a double portion that's given to a firstborn. And it says, on the day that he causes his son to inherit. So the Midrash says, during the day, you can divvy out inheritance, but you do not give out inheritance at night. Now we have to understand this. Amar Abaye, Ela me'ata deshachi bimama hu deyarti le bene, man deshachi belelia la yarti le bene. So Abaye understands this to mean that it depends when a person dies, right? There's no inheritance at night. We say there's no inheritance at night. So now what does that mean? Abaye asks rhetorically, are you trying to tell me that if someone dies during the day, then his children will inherit? Because there is inheritance during the day. But if someone happens to die at night, then there's no inheritance. The children will not inherit in that case. Is that what you're telling me? That you give out inheritance in the day, but not at night? So that at night nobody inherits? No, that doesn't make sense. Dilma din nechalot ka'amar. So Abaye says, you must have meant that it's the adjudication of inheritance that happens during the day and not the night. See, it doesn't matter when a person dies. If a person dies during the day or the night, that makes no difference. It's a few days later, whenever they get around to it, then they they come, they have a bet din, they get witnesses, there's a will, and they adjudicate what the will was or what the witnesses saw and what they say. And then they adjudicate who will get which part of the inheritance. The adjudication has to be during the day, because after all, courts meet during the day and generally do not meet at night. Detanya v'hayita libnei Israel lechukat mishpat ura'a kol ha'parasha kula leyot din. And we know this, that adjudication of inheritance is in fact a legal thing. It's not like other business deals. If we have a partnership and we want to break apart the partnership, so we can just get together and we decide. You don't need to go to court unless there's a problem and a dispute, then you go to court. But just to go through with a regular case of separating a partnership, you can do that without a court. However, inheritance laws, even if everybody's in agreement, still you need a court to make it official. And so that's why this paragraph, or the whole paragraph about the laws of inheritance, it says at the end of that paragraph that this will be for Bnei Israel a statute of judgment. Why is it called here judgment? This parasha is placed here in the context of judgment to tell us that the adjudication of inheritance is considered judgment and therefore can only be done during the daytime. וכדרבי יהודה, דאמר רבי יהודה, שלושה שנכנסו לבקר את החולה, רסו כותבין, רסו עושין דין, שניים כותבין ואין עושין דין. And this is in accordance with what Rabbi Yehuda said. Because he said that if three people come to visit someone who's sick, very sick, he's on his deathbed, and the sick person, he's explaining his will, and so if those three people, they can either act as witnesses or as judges, if they're coming during the day, which we're about to say. So if they come to visit the sick, if they want, they can write down the will and act as witnesses. Now, really only need two people to be witnesses, but you could have three witnesses also. So if they want, they can write it down and sign it, and then they'll be witnesses. Or they can be, since they're three men, they can be a bet din right there, and they can adjudicate the inheritance as a bet din. That's if they're three, they can do one or the other. Now, if there's only two people that are visiting the sick person, then they can write down, meaning they can be witnesses, but they can't be judges because you need three people to be a judge. That's what Rav Yehuda said. So you see that he saw adjudication of inheritance as being a din, as requiring three, because it's an official court procedure. V'amar Rav Chisda, lo shanu ela bayom. אבל בלילה אפילו שלושה כותבין ואין עושים דין. Rav Chisda says about that this is only true during the day. Then if there's three people, they could be witnesses or they can be judges. But if the three people come at night, right, so two, or certainly for sure two, but even if there's three people but they come at night, then they can still be witnesses. You can be a witness and you can witness something at night, but you cannot be a court at night, so they can write it down, but they cannot adjudicate as a court. My tama tavulahu adim ve'en ayed na'asa dayan. Now, what's the reason they can't be a court? This means they can't be a court not only at night, they can't even be a court on the next day. Why? Because they are witnesses, and witnesses cannot turn into judges. You can't be a witness and a judge about the very same case. And so therefore, these three people, they came to visit the sick person at night. At night, they can only be witnesses. Fine, they're witnesses, and they signed a will. And then the person dies, let's say, and now the next day or some other day, they are coming to adjudicate. Those three people cannot be the judges on the case because they're going to be testifying, so they can't examine their own testimony. And therefore, they cannot be the judges for that case at all. Amar le in hachinameh. And Rabba bar Chana said to Abaye, that's exactly what I was saying. He said the original statement here, and Abaye says, I don't understand. Are you saying that no one, if you die at night, then there's no inheritance? Maybe you mean this. And he said, yes, that's in fact exactly what I meant. Baruch Adonai le'olam. Amen ve'amen.